Good day, everyone. This is Rochelle Massa reporting on real estate property ownership. Okay, this is the concept of ownerships. So let's define what is ownership. Ownership is the independent right of a person to the exclusive enjoyment and control of a property, including its disposition and recovery, subject only to the restriction established by law and rights of others. Ownership, legal concept of real property. Real estate and real property have their legal meaning in accordance with RA 9646 or REZA law. Real estate refers to the land and all those items which are attached to the land. It is the physical, tangible entity together with all the addition or improvements on, above, or below the ground. Real property includes all the rights, interests, and benefits related to the ownership of real estate. Bundle of legal rights. Rights of ownership over a real property which are inherent or apportionate thereto without any limitations or restrictions over those imposed by the contract. It includes the following rights. Rights incident to ownership. They are the right to enjoy and dispose of a property without other limitation than those established by law, to file action against third parties to recover ownership, to use force as may be reasonably necessary to repel or prevent an actual or threatened unlawful invasion or usurpation of his property. Article 429 NCC relate to Article 312 RPC to enclose or fence property, wall ditches, live or dead hedges, or by any other means without detriment or servitudes constitute thereon. The demand indemnity for damages caused to property. The right to compensation in the event of expropriation. The right to be restored possession in case of unlawful disposition. The right to the surface and subsurface of the land. Right to construct thereon any works, plantation, and excavation without detriment to servitude and subject to special laws without right to complain or the reasonable requirements of aerial navigation. The right to hidden treasure, the right to accession and fruits of the property, the right to quiet title to real property or any interest therein. The basic type of estate: freehold ownership, backed by title; fee simple, absolute, unrestricted estate in perpetuity; fee till, designed to pass to heirs; life estate, ownership only as long as grantee is alive; less than freehold, limited possession; state for years, a lease maximum of 99 years as per Civil Code. Tenancy, leases or rentals period may be specified, or if not, the lessor may terminate at will. This is the diagram of the types of property ownership, wherein there are three kinds: individual sole ownership, joint ownership or co-ownership, property ownership by nomination. So let's all specify the four types of joint ownership or co-ownership: joint tenancy, tenancy in entirety, tenancy in common, and coparcenary. What is individual ownership or sole proprietorship? A sole proprietorship is an unincorporated business that one person owns and manages. As the business and the owner are not legally separate, it is the simplest form of business structure. It is also known as individual entrepreneurship, sole trader, or simply proprietorship. What is co-ownership of property? Property co-ownership means that more than one person has an ownership interest in a piece of real estate. Tenancy in common, joint ownership, community, property, and tenancy by the entirety. All are examples of co-ownership. The legal procedure for co-ownership. When you become a co-owner of a property, you form a legal relationship. This is governed by a co-ownership agreement signed by you and by your joint partners. Tenancy in common and joint tenancy are the two most common types of co-ownership agreements. Tenancy in common property. Tenancy in common allows two or more parties to own a financial share of a property and transfer their interests independently. This provides a more flexible form of property co-ownership, allowing parties to own a land in equal or unequal shares. Joint tenants are full ownership. Couples have traditionally used joint tenancy. As a couple, this tenant owns the entire property. This type of co-ownership includes survivorship rights, which means that if the other co-owner dies, the surviving tenant inherits the entire property. The benefit of property owned through co-ownership. Capability to pool funds with friends or family to purchase your first home or enter the market as an investor sooner. There is no need to save up for a large deposit. You can pool your borrowing power to borrow the remaining funds from a loan provider. Increases the number of property options available to you. Reduces both transactions and living cost. The disadvantages of the property owned by two or more persons. Property co-ownership can put up relationship to the test while also putting your finances at risk. Friendship change and sometimes a squabble occurs, which can be disrupted and costly for the co-owner. If a co-owners use the co-owned property as security for their mortgage, they are liable for each other's debts. A co-owner may not always share ongoing costs, which can lead to conflict. One owner may wish to sell while the others do not. Co-ownership may have an impact on your future borrowing power because some lenders considers the entire co-ownership loan to be your responsibility, not just your share of the loan. What are the rights of a co-owner in the Philippines? Rights to be proportionate share of the benefits and changes associated with co-ownership. The right to use the thing owned in common as long as it does not harm the co-interest ownership or prevent the other co-owners from using it. The right to file a legal action to evict occupants in a co-ownership. The right to compel the other co-owners to contribute to the expenses for the preservation of the thing owned in a common as well as taxes. The right to compel co-owners to pay a pro-rate share of the above-mentioned expenses and income. The right to partition real property at any time. The right to make changes with the consent of the co-owners. The right to alienate, assign, mortgage, or substitute a portion of his or her shares of ownership. Coparcenary. Coparcenary refers to the type of a property ownership where multiple people inherit the same property, and each person owns an undivided, transferable interest in the property. The term coparcenary has mostly been replaced with tenancy in common. Coparcenary denotes joint heir in the Hindu undivided family, who shares legal rights for inheriting property, title, and money as defined under Hindu succession laws. In other words, this person can demand the property partition. According to the Hindu Succession Act, if there is no will, the property will pass to Class 1 heirs, which include the deceased spouse, children, and mother. If there are no Class 1 heirs, it will be passed down to the Class 2 heirs, including the father, grandchildren, and siblings. According to property ownership by nomination, who is a nominee? According to the law, nominee of a immovable property is merely a trustee, entitled to receive the money proceeds due to deceased person on behalf of their legal heirs, only until the court determine who is entitled to the property under the succession laws. Well, the nominee will be the change of it. Put another way, the nominee is only the property caretaker, not the owner. As a trustee, they will only do so. You will be legally obligated to transfer the asset to the legal heirs. What is the definition of legal heir? The legal heir to a deceased person state is the person named in the will. The legal heir has the right to be the valid owner of the deceased assets. In the absence of choice, the legal heirs are determined by succession laws. This also specifies who gets what percentage of the assets. To summarize, a nominee does not have the right to receive the property, whereas a will determines who will ultimately own it. What are the limitations and rights of ownership? Those imposed in general by the state in the exercise of the power of taxation, police power, and power of eminent domain. Those imposed by law such as legal easement, requirement of the legitimate succession, zoning, building code, rent control, urban and agrarian reform, subdivision regulation, and escheat. Those imposed by the grantor of the property on the grantee by contract, such as donation, last will, or usufruct, and those imposed by the owner himself, such as voluntary easement, lease, or mortgage. Escheat is the reversion of automatic conveyance of realty to the government. Upon owner's death, due to the absence of a will, heirs or other legal claimants ascertainable of the face of the title, or when the owner does not pay his taxes. Right to surface and air right. Land in its legal signification extends from the surface downwards to the center of the earth and extends upward indefinitely to the skies. Right to hidden treasure. It simply means that hidden treasure belongs to the owner of the land, building, other property on which it is found. Right of accession. Landowner also owns everything produced, incorporated, or attached it is meant to be. In general, the ownership of property gives the right by accession to everything which is produced thereby, or which is incorporated or attached thereto, whether naturally or artificially. With respect to produce of property, to the owner belongs the natural fruits, the spontaneous product of the soil, the industrial fruit, those produced by land cultivation or labor, the civil fruits, the rental income of the buildings or lands. With respect to immovable property, the owner of the land on which anything has been built, sown, or planted in good faith shall have the rights to appropriate as his own the works, sowing, or planting after payment of indemnity provided by law, or the obliged to the builder or planter to pay the price of the lands. What is the meaning of fee simple? Fee simple is defined as the absolute right of ownership without any limitation to any particular class or heirs or restriction, but subject to the inherent and statutory restriction. What is title? It is not synonymous with torrent certificate of title, but rather it is a generic word which means proof, evidence, or monument to ownership, such as tax declaration, realty tax receipts, deed of sale, and torrent certificate of title. But of course, the best title or best evidence of ownership is the torrent title, because it is indefeasible, imprescriptible, and binding against the whole world. This is the example for the transfer certificate of title. Role on the right to own land on real estate in the Philippines. The general rule, only Filipino citizens and corporations at least 60% of the capital of which is owned by Filipinos are entitled to acquire and own land in the Philippines. Exception to the general rule. Alien acquisition of real estate in the Philippines is allowed in the following cases: acquisition before the 1935 Constitution, acquisition through hereditary succession by the legislador, purchase of not more than 40% interest in a condominium project of RA 4726, purchase by former natural-born citizens subject to limitations prescribed by BP 185 residential lot and RA 8179 commercial lot. A Filipino who marries an alien retains her Philippine citizenship unless the law of her husband's country makes her assume the citizenship of her husband because of such marriage, and can therefore acquire real estate in the Philippines. Former natural-born Filipino citizens who applied for dual citizens under RA 9225. This is my references for my report, and thank you.